Today I am talking about the philosophy of our constitution. Actually, the founding fathers of our nation thought it proper to have a constitution of its own. So they gave a philosophy regarding our constitution, and on the basis of the philosophy of our founding fathers, our constitution has been framed on 26th January 19, which has been initiated by 26th January 1950. Now I am talking about the philosophy of the constitution. Every constitution has a philosophy of its own. For the philosophy underlying our constitution, we must look back into the historic objectives resolution of Pandit Nehru, which was adopted by the Constituent Assembly on January 22, 1947, and which inspired the shaping of the constitution through all its subsequent stages. It reads thus: the Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw up for her future governance a constitution wherein the territories that now comprise British India, the territories that now form the Indian states, and such other parts of India as are outside British India, and the states as well as such as territories as are willing to be constituted into the independent sovereign India shall be a union of them all, and wherein the said territories were with their present boundaries or with such other as may be determined by the Constituent Assembly and thereafter according to the law of the Constitution shall possess and retain the status of autonomous units, together with residuary powers, and exercise all powers and functions of government and administration, save and except other powers and functions as are vested in or assigned to the Union, or as are inherent or implied in the Union or resulting therefrom, and wherein all power and authority of the sovereign independent India, its constituent parts and organs of governments are derived from the people, and wherein shall be guaranteed and secured to all the people of India justice, social, economic, and political equality of status, of opportunity, and before the law, freedom of thought, expression, belief, faith, worship, vocation, association, and action, subject to law and public morality, and wherein adequate safeguards shall be provided for minorities, backward and tribal areas, and depressed and other backward classes, and wherein shall be maintained the integrity of the territory of republic and its sovereign rights on land, sea, and air according to justice and the law of civilized nations, and the ancient land attain its rightful and honored place in the world, and make its full and willing contribution to the promotion of world peace and welfare of mankind. In the words of Pandit Nehru, the aforesaid resolution was something more than a resolution. It is a declaration, a firm resolve to place an undertaking, and for all of us dedication. It will be seen that the ideal embodied in the above resolution is faithfully reflected in the preamble to the Constitution, which, as amended in 1976, summarizes the aims and objects of the Constitution. We, the people of India, this is very important. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. The importance and utility of the preamble has been pointed out in several decisions of our Supreme Court. Though by itself it is not enforceable in a court of law, the preamble to a written constitution states the objects which the constitution seeks to establish and promote, and also add the legal interpretation of the Constitution where the language is found to be ambiguous. For a proper appreciation of the aims and aspirations embodied in our Constitution, therefore, we must turn to the various expressions contained in the preamble as reproduced above. It indicates the source from which the Constitution derives its authority. B. It also states the object which the Constitution seeks to establish and promote. As has been already explained, the Constitution of India, unlike the preceding Government of India Acts, is not a gift of British Parliament. It is ordained by the people of India through their representatives assembled in a sovereign constituent assembly, which was competent to determine the political future of the country in any manner it liked. The words we the people of India adopt, enact, and give to ourselves this Constitution, thus declare the ultimate sovereignty of the people of India, and the Constitution rests on their authority. Sovereignty means the independent authority of a state. It means that it has the power to legislate on any subject, and that it is not subject to the control of any state or external power. The preamble declares, therefore, in unequivocal terms that the source of all authority under the Constitution is the people of India, and that there is no subordination to any external authority. While Pakistan remained a British dominion until 1956, India ceased to be a dominion and declared herself a republic since the making of the Constitution in 1949. It means a government by the people and for the people. We have the elected president at the head of our state, and all offices, including that of the president, will be open to all citizens. On and from 26th January 1950, when the Constitution came into force, the Crown of England ceased to have any legal or constitutional authority over India, and no citizen of India was to have any allegiance to the British Crown. But though India declared herself a republic, she did not sever all ties with the British Commonwealth, as did Eyre by enacting the Republic of Ireland Act 1948. In fact, the conception of the Commonwealth itself has undergone a change owing to India's decision to adhere to the Commonwealth without acknowledging allegiance to the Crown, which was symbol of unity of the old British Empire and also of its successor, the British Commonwealth of Nations. British Commonwealth of Nations, it is this decision of India which has converted the British Commonwealth, a relic of imperialism, into free association of independent nations under the honorable name of the Commonwealth of Nations. This historic decision took place at the Prime Minister's Conference at London on April 27, 1949, where our Prime Minister Pandit Nehru declared that Withstanding her becoming a sovereign independent republic, India will continue her full membership of the Commonwealth nations and her acceptance of the king as the symbol of free association of the independent nations and as such the head of Commonwealth. It is to be noted that this declaration is extra legal and there is no mention of it in the Constitution of India. It is voluntary declaration and indicates a free association and no obligation. It only expresses the desire of India not to sever her friendly relations with England people, even though the tie of political subjugation was severed. The new association was an honorable association between independent states. It accepts the crown of England only as a symbolic head of the Commonwealth, having no function to discharge in relation to India as belonged to him prior to the Constitution, and having no claim in the allegiance of citizens of India. Even if the King or Queen of England visits India, he or her will not be entitled to any precedence over the President of India. Again, though as a member of the Commonwealth, India has a right to be represented on Commonwealth conferences, decisions at Commonwealth references will not be binding on her, and no treaty with the foreign powers or declaration of war by any member of the Commonwealth will be binding on her without her express consent. Hence, this voluntary association of India with the Commonwealth does not affect her sovereignty to any extent, and it would be open to India to cut off its association at any time she finds it not to be honorable or useful. As Pandit Nehru explained, it is an arrangement by free will to be terminated by free will. The great magnanimity with which India took this decision in the face of a powerful opposition at home, which was the natural reaction of the manifold grievances under the imperialistic rule, and great fortitude which the association has still been maintained under the pressure of the repeated disappointments, the strain of baffling international alignments, and the 1976 upsurge of racialism in England speak volumes about the sincerity of India's pledge to contribute to the promotion of world peace, which is reiterated in Article 51 of the Constitution. The state shall endeavor to A. Promote international peace and security. B. Maintain just and honorable relation between nations. C. Foster respect for international law and treaty obligations in the dealings of organized people with one another, and encourage settlement of international disputes by arbitration. The fraternity which is professed in the preamble is thus not confined within the bounds of national territory. It is ready to overflow them to reach the loftier ideal of universal brotherhood, which can hardly be better expressed than in the memorable words of Pandit Nehru. The only possible real object that we, in common with other nations, can have is the object of cooperating in building up some kind of world structure. Call it one world, call it what you like. Thus, though India declares her sovereignty to manage her own affairs in no unmistakable terms, the Constitution does not support isolationism or jingoism. Indian sovereignty is consistent with the concept of one world, international peace and amity. The picture of a democratic republic which preamble envisages is democratic not only from the political but also from the social standpoint. In other words, it envisages not only a democratic form of government but also a democratic society infused with the spirit of justice, liberty, equality, and fraternity. As a form of government, the democracy which is envisaged is, of course, a representative democracy, and there are in our constitution no agencies of direct control by the people, such as referendum or initiative. The people of India are to exercise their sovereignty through a parliament at the center and a legislature in each state, which is to be elected on adult franchise, and to which the real executive, namely the Council of Ministers, shall be responsible. Though there shall be an elected president at the head of the union and a governor nominated by the president at the head of each state, neither of them can exercise any political function without the advice of Council of Ministers, which is collectively responsible to the people's representatives in the respective legislature, excepting functions which the governor is authorized by the Constitution itself to discharge in his discretion or in his individual responsibility. The Constitution holds out equality to all citizens in the matters of choice of their representatives who are to turn the governmental machinery. The ideal of democratic republic enshrined in the preamble of the Constitution can be best explained with the reference to the adoption of universal suffrage, which has already been explained, and the complete equality between the sexes not only before the law but also in the political sphere. Political justice means the absence of an arbitrary distinction between man and man in the political sphere. In the order to ensure the political justice held out by the preamble, it was essential that every person in the territory of India, irrespective of his propriety or educational qualifications, should be allowed to participate in the political system like any other person. Universal adult suffrage was adopted with this object in view. This means that every 5 years, the members of the legislatures of the union and of each state shall be elected by the vote of the entire adult population according to the principle one man, one vote. The offering of equal opportunity to men and women, irrespective of their caste and creed, in the matter of public employment and implements this democratic ideal. The treatment of minority, even apart from the constitutional safeguards, clearly brings out that the philosophy underlying the Constitution has not been overlooked by those in power. The fact that members of the Muslim and Christian communities are, as a rule, being included in the Council of Ministers of the Union as well as the states in the Supreme Court and even in diplomatic missions without any constitutional reservation in that behalf amply demonstrate that those who are working the Constitution have not missed its true spirit, namely that every citizen must feel that this country is his own, that this democratic republic stands for the good of all the people, is embodied in the concept of a welfare state which inspires the directive principles of state policy. The economic justice assured by the preamble can hardly be achieved if the democracy envisaged by the Constitution were confined to a political democracy. In the words of Nehru, democracy has been spoken of chiefly in the past as political democracy, roughly represented by every person having a vote. But a vote by itself does not represent very much to a person who is down and out, to a person, let us say, who is starving or hungry. Political democracy by itself is not enough except that it may be used to obtain a gradually increasing measure of economic democracy, equality, and the spread of good things of life to others and removals of gross inequalities. or as Dr. Radhakrishnan has put it, poor people who wander about, find no work, no wages, and starve, whose lives are continual round of sore affliction and pinching poverty, cannot be proud of the Constitution or its law. In short, of Indian Constitution promises not only political but also social democracy, as explained by Dr. Ambedkar in his concluding speech in the Constituent Assembly. Political democracy cannot last unless there lies at the base of its social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity, which are not to be treated as separate items in a trinity. They form a union of trinity in the sense that the divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality, equality cannot be divorced from liberty, nor can liberty and equality be divorced from fraternity. The state in a democratic society derives its strength from cooperative and dispassionate will of all its free and equal citizens. Social and economic democracy is the foundation on which political democracy would be a way of life in the Indian polity. C. The banishment of poverty, not by exploitation of those who have, but by the multiplication of the national wealth and resources and an equitable distribution thereof amongst all who contribute towards its production, is the aim of the state in our aim of the state envisaged by the directive principles. Economic democracy will be installed in our subcontinent to the extent that this goal is reached. In short, economic justice aims at establishing economic democracy and a welfare state. The ideal of economic justice is to make equality of status meaningful and life worth living at its best, removing inequality of opportunity and of status, social, economic, and political. Social justice is a fundamental right. Social justice is the comprehensive form to remove social imbalance by law, harmonizing the rival claims or the interests of different groups and or sections in the social structure or individuals, by means of which alone it would be possible to build up welfare state. The three have to be secured and protected with social justice and economic empowerment and political justice to all the citizens under the rule of law. Democracy, in any sense, cannot be established unless certain minimal rights, which are essential for a free and civilized existence, are assured to every members of the community. The preamble mentions these essential individual rights as freedom of thought, expression, belief, faith, and worship, and these are guaranteed against all the authorities of the state by Part 3 of the Constitution, by Article 19, 25 to 28. Subject, of course, to the implementation of the directive principles for the common good, Article 31C, and the fundamental duties introduced in Article 51A by the 42nd Amendment 1976. Liberty should be coupled with social restraint and subordinated to the liberty of the greatest number for common happiness. Guaranteeing of certain rights to each individual would be meaningless unless all the inequality is banished from the social structure and each individual is assured of equality of status and opportunity for the development of the best in him, and the means for the enforcement of the rights guaranteed to him. This object is secured in the body of the Constitution by making illegal all discriminations by the state between citizen and citizen simply on the ground of religion, race, caste, sex, or place of birth. By throwing open public places to all citizens, by abolishing untouchability, by abolishing titles of honor, by offering equality of opportunity in matters relating to employment under the state, by guaranteeing equality before the law and equal protection of laws as justiciable rights. In addition to the above provisions to ensure civic equality, the Constitution seeks to achieve political equality by providing the universal adult franchise and by reiterating that no person shall be either excluded from the general electoral roll or allowed to be included in any general or special electoral roll only on the ground of his religion, race, caste, and sex. That is described in Article 325 of the Constitution. Apart from these general provisions, there are special provisions in the Directive Principles Part 4 which enjoin the state to place the two sexes on an equal footing in the economic sphere by securing to men and women equal rights to work and equal pay for equal work. Article 39. The realization of so many objectives would certainly mean an expansion of the function of the state. The goal envisaged by the Constitution, therefore, is that of a welfare state and the establishment of a socialist state. At the Awadi session in 1955, Congress explained this objective as establishing a socialistic pattern of society by resolution. In order to realize the object of Congress and to further the objectives stated in the preamble and directive principle of state policy of the Constitution of India, planning should take place with a view to the establishment of a socialistic pattern of society where the principal means of production are under social ownership or control. Production is progressively speeded up and there is equitable distribution of the national wealth. How far this end has been already achieved will be explained in chapter 9, where it will also be pointed out how till 1992 the trend has been from a socialistic pattern towards a socialistic state, bringing industries and private enterprises under state ownership and management and carrying on trade and business as a state function. That the goal of the Indian polity is socialism was ensured by inserting the word socialist in the preamble by the Constitution 42nd Amendment Act 1976. It has been inserted to spell out expressly the high ideas of socialism. It is to be noted, however, that the socialism envisaged by the Indian Constitution is not the usual scheme of state socialism, which involves nationalization of all means of production and the abolition of private property. As the then Prime Minister Indira Gandhi explained, we have always said that we have our own brand of socialism. We will nationalize the sectors where we feel the necessity. Just nationalization is not our type of socialism. Though the word socialism is vague, our Supreme Court has observed that its principal aim is to eliminate inequality of income and status and standards of life, and to provide a decent standard of life to the working people. The Indian Constitution, therefore, does not seek to abolish private property altogether but seeks to put it under restraint so that it may be used in the interests of the nation, which includes the upliftment of the poor instead of a total nationalization of all property and industry. It envisages a mixed economy but aims at offering equal opportunity to all and the abolition of vested interests. From 1992 onwards, the trend is now away from socialism to privatization. Investment in many public enterprises has been divested in favor of private persons, and many industries and services which were reserved for the government sector have been thrown open for private enterprise. This is in keeping with the worldwide trend after the collapse of socialism in the USSR, the Eastern European countries, but the constitutional obligation to pay compensation to the private owner for state acquisition has been taken away by repealing Article 31 by the Constitution 44th Amendment Act 1978, as will be further explained under Chapter 8 Post. And unity amongst the inhabitants of this vast subcontinent torn asunder by a multitude of problems and vociferous forces was the first requisite for maintaining the independence of the country as well as to make the experiment of democracy successful. The ideal of unity has been buttressed by adding the words and integrity of the nation in the preamble by the Constitution 42nd Amendment Act 1976, but neither the integration of the people nor a democratic political system could be ensured without infusing a spirit of brotherhood amongst the heterogeneous population belonging to different races, religions, and cultures. The fraternity cherished by the framers of the Constitution will be achieved not only by abolishing untouchability amongst the different sects of the same community, but by abolishing all communal or sectional or even local or provincial anti-social feelings which stand in the way of the unity of India. Democracy would indeed be hollow if it fails to generate this spirit of brotherhood amongst all sections of the people, a feeling that they are all children of the same soil, the same motherland. It becomes all the more essential in a country like India, composed of so many races, religions, languages, and cultures. Article 1 of the Declaration of Human Rights 1948, adopted by the United Nations, says all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. In this spirit of brotherhood, that the preamble of our Constitution reflects, the unity and fraternity of people of India, professing numerous faiths, has been sought to be achieved by the enshrining the ideals of secular state, which means that the state protects all religions equally and does not itself uphold any religion as the state religion. The question of secularism is not one of sentiments but one of law. The secular objective of the state has been specifically expressed by inserting the word secular in the preamble by the Constitution 42nd Amendment Act 1976. Secularism is a part of the basic structure of the Constitution. There is no provision in the Constitution making any religion the established church as some other constitutions do. On the other hand, the liberty of belief, faith, and worship promised in the preamble and is implemented by incorporating the fundamental rights of all citizens relating to freedom of religion in Article 25 to 29, which guarantee to each individual freedom to profess, practice, and propagate religion, assure a strict impartiality on the part of the state and its institution towards all religions. This itself is one of the glowing achievements in Indian democracy when her neighbors such as Pakistan, Bangladesh, Sri Lanka, and Burma uphold particular religions as state religions. For further discussion on secularism, see under Chapter 8, Article 25 post. A fraternity cannot, however, be installed unless the dignity of each of its members is maintained. The preamble therefore says that the state in India will assure the dignity of the individual. The Constitution seeks to achieve this object by guaranteeing equal fundamental rights to each individual so that he can enforce his minimal rights if invaded by anybody in a court of law. Seeing that these justiciable rights may not be enough to maintain the dignity of an individual if he is not free from wants and misery, a number of directives have been included in Part 4 of the Constitution, exhorting the state so to shape its social and economic policies that inter alia all citizens, men and women, equally have the right to an adequate means of livelihood. Article 39A, just the human conditions of work. Article 42, and a decent standard of life and full enjoyment of leisure and social and cultural opportunities. Article 43, our Supreme Court has come to hold that the right to dignity is a fundamental right. In order to remove poverty and to bring about a socio-economic revolution, the list of directives was widened by the Constitution 42nd Amendment Act 1976, and it was provided that in order that such welfare measures for the benefit of the masses may not be defeated, any measure for the implementation of any of the directives shall be immune from any attack in the courts on the ground that such measure contravenes any person's fundamental right under Article 14 to 19. The philosophy contained in the preamble, as explained in the foregoing pages, has been further highlighted by emphasizing that each individual shall not only have the fundamental rights in Part 3 of the Constitution to ensure his liberty of expression, faith and worship, equality of opportunity and the like, but also a corresponding fundamental duty such as to uphold the sovereignty, unity and integrity of the nation, to maintain secularism and the common brotherhood amongst all the people of India. This has been done by inserting Article 51A, laying down 10 fundamental duties by the Constitution 42nd Amendment Act 1976. See further under Chapter 8 post. A fitting commentary on the foregoing contents of the preamble to our Constitution can be best offered by quoting a few lines from Professor Ernest Barker, one of the modern thinkers on democratic government. There must be a capacity and a passion for the enjoyment of liberty. There must be a sense of personality in each and of respect for personality in all, generally spread through the whole community before the democratic state can be truly achieved. Perhaps it can be fairly demanded only in the community which has achieved the sufficient standard of material existence and a suffering degree of national homogeneity to devote itself to an ideal of liberty which has to be worked out in each by the common effort of all. If problems of material existence are still absorbing the ideal of living a common life of freedom, in other words, of attaining the particular quality of life, will seem an ideal dream. If again the problems of national homogeneity are still insistent, and there is no common feeling of fellowship if some sections of the community are regarded by others, whether on the ground of their inferior education or on ground of their inferior stock or any other ground, and essentially alien and heterogeneous, the ideal of common life of freedom will seem equally illusory. Combining the ideals of political, social, and economic democracy with that of equality and fraternity, the preamble seeks to establish what Mahatma Gandhi described as the India is my dreams, namely an India in which the poorest shall feel that it is their country in whose making they have an effective voice, an India in which all communities shall live in perfect harmony. There can be no room in such an India for the curse of untouchability or the curse of intoxicating drinks and drugs. Women will enjoy the same rights as men. No wonder such successful combination in the text of our preamble would receive an unstinted approbation from Ernest Barker, who has reproduced this preamble at the opening of his book on social and political theory, observing that the preamble to the Constitution of Indian States in a brief and pithy form the argument of much of the book, and it may accordingly serve as a keynote.